Here today in the case of State versus Richard Alexander Murdaugh. He is here for a bond setting on two Beaufort County arrest warrants. That is 23K-235570 and K-235571. Both of those are for obtaining signature of property by false pretenses at a greater than $10,000 in violation of 1613-240, subsection 1, that is a 0 to 10. Your Honor, Mr. Murdaugh is here represented by his counsel, Mr. Harpootlian and Mr. Griffin. Obviously, my name is Creighton Waters. I'm here for the state along with Megan Burstead and Don Zelenka. And the facts of this particular matter, Your Honor, if I can go through them very quickly, deal with the death of the longtime housekeeper of the Murdaughs. Her name was Gloria Satterfield, and she was their housekeeper for 20 plus years. She helped raise those children. And in February 2nd of 2018, she suffered a fall in the family home at Moselle in Colleton County, and she died on February 22nd of 2018 in the hospital based on injuries from that particular fall. She had two sons and has two sons. That's Tony Satterfield and Brian Harriet, and we do have family present in the courtroom today. Could y'all raise your hand, family, please? All right. And they are currently represented by attorney Eric Bland and Ronnie Richter. Mr. Bland, on behalf of the victims, would like to address the court at the appropriate time. Your Honor, Mr. Murdaugh, as you may know, is a longtime lawyer in the state of South Carolina, does a lot of tort work. And at the funeral of Miss Satterfield, Mr. Murdaugh tells the family, hey, she fell at my house, it was because of the dogs, it was my fault, and I'm going to take you to a lawyer so that y'all can file a claim and get some compensation for the death of your mom. And he takes the boys to a friend of his, a very close friend of his, a person by the name of Corey Fleming. And Your Honor, as you're well aware, many times in these sorts of cases, there ends up being a structured settlement. And there is a company, a legitimate company here that operates in South Carolina called Forge Consulting. And what they do is they help facilitate these structured settlements in certain cases where that is approved by the court. But as Your Honor also knows, those have to be approved by the court. Mr. Murdaugh, it appears back in 2015, set up a bank account with the Bank of America in the name of Richard Alexander Murdaugh, DBA Forge. And it appears that this account was nothing more than an illusion, a fabrication, in order to create the illusion that these checks that he was getting in various settlements were going to a legitimate settlement consultant, when in reality they were going into an account that he controlled. And that's how this scheme took place in this particular case. And this led to a chain of events, Your Honor, that I've never seen before. Mr. Fleming talks the boys into appointing as PR a person at Palmetto State Bank, where Mr. Murdaugh has a long relationship, a guy by the name of Chad Westendorf. He gets appointed on December 18th, 2019, and on the very next day, December 19th, 2019, he files a petition to approve a settlement, which is a $500,000 settlement on the homeowner's policy. The disbursement in this petition says $475 for the wrongful death, $25 for survival, and $5,000 for the med pay. And in that petition as well, there is $166,000 for attorney's fees, and then $11,500 on the nose for costs. And ultimately then, not long after that, Mr. Fleming and his law firm issues a check at the direction of Mr. Murdaugh, made out just simply to the name Forge. And Mr. Murdaugh takes that particular check. It is for $403,500. It makes no sense with the disbursements that were in the petition to approve the settlement, and he deposits that into this Forge account that he controls. And Your Honor, I was able to review the bank records about that, and what we see is that's deposited in January of 2019, and by March 2019, he has transferred all of that money out of that Forge account he controls into his personal checking account, where they are spent on personal use and family expenses. But that's not the end of it, Your Honor. There's also an umbrella policy that's got a much higher limit, and ultimately, Mr. Fleming negotiates a $3.8 million settlement with the insurance company on that umbrella policy. And then what we see is there is an unfiled petition The caption has changed. It doesn't have Mr. Murdaugh's name on it. It just says In Re Gloria Satterfield. The Murdaugh name is removed, and it is this petition to approve a settlement is on May 13th, 2019, and it is actually for $4,305,000. So it is for the 3.8 plus the 505 that was from that previous petition. There's no mention of structure. There's no mention of a structured settlement. And in the disbursement that's set out there, there's supposed to be $2,765,000 that's supposed to go to the beneficiaries. And then there's also $105,000 in costs on the nose. Again, zero. $105,000, not 21 cents, not 37 cents, $105,000. So that disbursement also has in there for attorney's fees and all the rest of it. And again, $2.7 million is supposed to go to these boys back here. And instead, Mr. Fleming sends a check to Forge at Mr. Murdaugh's direction on May 13th, 2019 for $2,961,911.95. And that represents the second charge. The first charge is the $403,000. The second charge is for the 2.9, almost $3 million. And again, Your Honor, when you look at the petition, the disbursements make no sense whatsoever. They don't bear any relationship to what was said in those petitions. But the reality is that $2.9 million went into that Forge account that Mr. Murdaugh controlled, and within a few months, he had transferred all that money for personal use. He had been carrying a $100,000 credit card balance for months. That gets paid off. He writes 300 and some odd grand to his father. He writes a check for 610 grand to himself. He writes a check for 125 grand to himself. Not a dime goes to this family back here, Your Honor. And interestingly, I noticed last night that one of the checks in there was an $84 check that he wrote to Scott Harriet, who was one of the family members back here. So he had over $3 million of money that should have gone to this family, or almost $3 million of money that should have gone to this family. And, yes, sir.
Let's wait for this conversation to end.
All right, yes, sir. We good? All right. All right, so in any event, he had all that money. He absconded with that money. He transferred it into his personal accounts, and he used it for his own personal use. Your Honor, there is one final check that was in October of 2020, over a year after all this other stuff occurred, and that was for $118,000 that Mr. Fleming also sent to Forge, that Mr. Murdaugh absconded with that as well. That is not one of the current charges, but that is because this is an ongoing investigation, Your Honor. This is the tip of the iceberg. This is an ongoing investigation, and I think there's going to be far more that we will reveal as we review these records. But it's important from a law enforcement standpoint and a prosecution standpoint that we go forward on the charges at a particular point in time that we're comfortable on, and that's what we've done here today. Your Honor, very quickly, the state would be asking for a surety bond here today in the neighborhood of $200,000. We would ask for GPS. And the reason for that is that we do believe that Mr. Murdaugh is a danger. He's already, by the previous charges that he had, he's been a danger to himself. And a man who's a danger to himself is a danger to others. The underlying facts of those, and there's already been a bond set on that, and I recognize that, but the underlying facts of those charges were in fact violent. Someone who is suicidal is also a danger to other people. Additionally, he's been apparently under treatment for a very severe opiate addiction, and Your Honor, doing a lot of drug cases, I know how powerful that is and how unmoored that can make someone. And then obviously we're all aware of the unspeakable tragedy that this family has suffered. His professional life is coming apart at the seams. He's facing very serious charges with additional ones to come, and that really can make someone very unmoored and very dangerous. And for that, Your Honor, I think that he is a danger. I think we also have to consider the fact of a flight risk. This is a man who, just here today, on the two charges we're here today, we're talking about over $3 million that was misappropriated. That's a lot of money. And I think inherently that makes somebody with that kind of means, with the kind of money that this man was dealing with, makes them capable of being a flight risk. Your Honor, if you steal $3.4 million, I believe you deserve a surety. I believe you deserve GPS. I believe that that would be treating him by the book. Your Honor, we've also prepared for your consideration, and I've shown this to the defense, an order-setting bond with some additional conditions that we would like to put up. We have a waiver of extradition, as well as the conditions that Your Honor may be familiar with from the state grand jury, but a few that I'd like to mention in here would be no wasting assets. We have some information that that there have been assets that are being sold and disposed of. We would ask for him to have to surrender all firearms in his possession and not to possess any firearms. We would also ask that any travel that he does, and I've done this with other clients of Mr. Harpootlian's, that any travel he does has to be not taken without a specific notice to and approval by the state, so that we can be sure where he is at any given time. Those are some of the conditions that we would raise. Also, Your Honor, just to point out, I believe that we are here, these are Buford charges. We are here by the consent of the defense, as well as the consent of the victims, to handle this matter here in Richland County today. Your Honor, at this time I would turn it over to Mr. Eric Bland, who represents the Satterfield family, to speak on behalf of the victims. Yes, sir. Thank you.
From the defense, before hearing from Mr. Bland.
Yes, sir. Thank you, Your Honor.
Please, Court, Your Honor.
Yes, sir.
Mr. Griffin and I are going to deal with this in sort of two prongs. He's going to discuss our memo we submitted in great detail. However, before we get to that, let me address a couple things. First of all, we're not here today to debate the allegations by the state. He's presumed innocent at this point, and while the allegations are just that, allegations, they're really not relevant to the bond Your Honor sets. The second thing I point out is this. When he was made aware of the charges in Hampton County, for which he's out on bond now, he brought himself from a treatment facility in Georgia, surrendered himself, a PR bond was set, he was released, he went to another treatment facility. We offered to SLED to let us know if you need him. We anticipated further charges. They did not take us up on our offer to have him come up under his own steam and surrender himself. They went to Orlando, Florida, took him into custody without giving us a heads up. That was not what was represented to me. They had some reason for doing it. He is not a flight risk. He surrendered himself. He was willing to surrender himself on this. And he's really got nowhere to go. He's from South Carolina, lived here his entire life. The second thing I think that's important to recognize is this. He has had at least a decade, if not longer, of severe addiction to Oxycontin and other opioids. Much of the conduct we're talking about, they're talking about here today, occurred because of that, some of it to fuel that, and certainly his judgment was impaired in a dramatic way. He is off of those. He has just completed almost 6 weeks of detox and treatment at an addiction center, 2 different centers. And we had hoped he would be able to go to the next step. He was ready to do that. We had permission from the magistrate for him to do that before he was arrested a week ago, last Thursday. And I think the state will agree that anybody with the kind of drug addiction that is evidenced by, I think we furnished letters to you from the addiction center in Georgia, needs continued treatment. We're not ready today to ask the court where, if it happens to be outside the state of South Carolina, we need to deal with whether or not insurance is available for that and where he would get the best treatment. But we would ask you to consider, and Mr. Griffin's going to go into this in greater detail, a personal recognizance bond. I mean, for him to have a surety bond means he's going to have to waste some of those assets that Mr. Waters is talking about on paying a bondsman. So, Your Honor, having pointed out his willingness to confront these charges, he hasn't run once, not going to run, and the fact that maybe he, at some point was a danger to himself in an opioid-addled mental condition, asked somebody to shoot him in the head. But that's not where he is today. He's been through 6 weeks of addiction treatment. He needs more. Your Honor, we'd ask you to consider a PR bond, and let Mr. Griffin go into greater detail on that.
Good morning, Your Honor. Jim Griffin. We emailed a copy of this memo to your chambers. I have an extra, if you'd like to hand it up.
Let's see what you emailed.
Okay. So, as Your Honor knows, the South Carolina Constitution actually guarantees the right of bail to persons who are charged with a non-capital offense. Not only that, South Carolina Code 15-10 in fact requires the issuance of a personal recognizance bond unless the state can prove that the defendant is a flight risk or a danger to himself, or excuse me, not to himself, but to the community or to any individuals. We don't think that the evidence presented here is that that the state establishing.
I haven't heard from any evidence at this point.
What?
Heard from the lawyers, I haven't heard from law enforcement.
That's right, and these are just charges, and we have representations from counsel for the state. The information provided to Your Honor in that regard, and it's summarized by Mr. Harpootlian, is that he voluntarily appeared once, was willing to voluntarily appear again. The state did not accept that offer, and he has actually been in custody since last Thursday, first in Orange County, Florida, where he was picked up at the treatment facility where he was located, and then transferred here over the weekend. Your Honor, with regard to factors that the court is directed to consider, the nature and circumstances of the offense charged, including the person's family ties, and we know Mr. Murdaugh has extensive family ties in the community, his employment up until he was confronted by his law firm of financial misconduct, in which he readily admitted to and resigned from the firm. He had been a long-time practicing lawyer in the state of South Carolina. His license has been suspended, and we are cooperating with the Office of Disciplinary Counsel in that regard, and he has complied with the rules applicable and the Supreme Court order that he notify all clients of his suspension. He's in full compliance with that. We're submitting an affidavit to Supreme Court today to support that. Character and mental condition, Your Honor, as Mr. Harpootlian addressed, he has a significant opioid addiction that he has received treatment for the last 6 weeks, intensive treatment. That opioid addiction, frankly, put him on the brink of losing his life. He attempted to commit suicide at the hand of another. And fortunately for him, his family, and those who love him, that was not successful. His length of residence in the community, he's 53 years old. He's lived nowhere but in South Carolina, primarily in Hampton County. Record of convictions, he has no record of convictions. Record of flight to avoid prosecution or failure to appear in other court proceedings. He has no record of flight to avoid prosecution or failure to appear in any other court proceedings. He has appeared every time he's been requested. Again, those are the factors that the court is directed to consider. I would point out again that the statute says you begin with a presumption of a PR bond. And, Your Honor, we think that is what he's entitled to. We had put in our memo a suggestion that he be subject to random drug testing. You know, he's willing to do that. He's committed to do that. He will do that regardless of this court's order. But, Your Honor, we think with random drug testing, that would be sufficient condition of release to ensure his appearance and that he's not a danger to the community. The Alex Murdaugh, who's not hooked on drugs, has lived a good, fruitful life and law-abiding life. Only when he got hooked on opioids did things turn south, and he truly regrets his conduct. Thank you, Your Honor.
Thank you, Your Honor. At this time, I would recognize Mr. Eric Bland, who is the designated representative of the victims in this matter. He would like to address the court.
May it please the court.
Yes, sir.
Judge Newman, my partner Ronnie Richter and I represent the victims. These are the Satterfield and the Harriet family. This is Brian Harriet. He's the direct victim of Alex Murdaugh. This is a sad day, Your Honor. It's a day for lawyers that we look upon another lawyer who stole money from clients. Alex Murdaugh stained our profession. He also put a black eye on this state. I disagree with Jim Griffin and Mr. Harpootlian. If he's an opioid addict for 20 years, how is it that he tried cases? How is it that he appeared before judges like you? How is it that he worked with his partners and represented clients? I do not believe that is the case. He is a clear and present danger to the citizens of this state and to my family. This is a man that used a gun on Labor Day weekend. This is a man that used a pen to steal $3.3 million with another $118,000 that's potentially going to be charged. It's no different than somebody walking into a bank and using a gun. We need to make sure that when somebody steals with a pen, it's the same as if they're stealing with a gun. We have a man here that you're going to hear from my partner has done some financial transactions within the last week and a half that shows that he is a financial risk to the victims of his crimes as well as the citizens of this state. Your Honor, we think that an appropriate bond should be placed, but it's a bond that has conditions, that he can't do financial transactions without court permission, that he, if he is going to stay on his property that's posted, that we have the ability to serve him with process. There's so many eyes in this courtroom today watching us. Today is the day that Alex Murdaugh needs to get comfortable getting uncomfortable. And I ask you to look at the crimes. This is a crime of a lawyer stealing money. My partner and I have been doing legal malpractice for 30 years, and we have never seen such a breach of trust. A man who stole money from the very family of the housekeeper that helped raise his kids. This is a crime that we've never seen before, and I think Your Honor would send a clarion bell depending on the type of conditions that you put on his bond. I appreciate the opportunity to appear before you. The victims also appreciate you presiding over this case, and with that said, my partner Ronnie Richter will address them.
You're sort of vague on what you're presenting to me. On the one hand, you say that you're convinced that Mr. Murdaugh presents a clear and present danger to society and to himself. On the one hand, and on the other hand, you say he should have a bond with conditions.
No, I want him not to have a bond. I would love it if this man was locked up and he couldn't harm anybody else. But there is a presumption that somebody is going to get bond. And if you're going to put bond, put those serious conditions on him that will restrain him. Our position is he does not deserve bond. He forfeited that right. He stole. He's a liar and a cheat. Thank you, Your Honor.
Sir.
May it please the Court, Your Honor.
Yes, sir.
Ronnie Richter, also for the victims. Your Honor, we want you to have the benefit in your consideration of some of these transaction documents. We're not here to argue the case, but it does go to the nature of the crime. And in this case, you have a former member of the bar who brazenly used that office to lie and to betray clients, and also to demonstrate a pattern of a willful disregard for court orders. And I'll hand these to you at one time at the end of my comments, but Your Honor, the case for us kind of starts with a petition that was filed for the approval of a $4.3 million settlement. There's many facts before that, but in this petition, it's very specific as to what's being asked and as to the disbursements that are being approved. And when Judge Mullen approves that petition by this order approving settlement, attached to the order is a very specific set of disbursements that were permitted from the $4.3 million. And Mr. Murdaugh would understand this as an attorney. By court order, the only disbursements that were allowed to be made from that money were set forth on this schedule, including a check for $2,765,000 that was to be directed to our clients as the beneficiaries of their mother's estate. So instead what happens, they take this court order, they don't so much as file it in the court record, but they bag this court order, Mr. Murdaugh and perhaps others. And this, Your Honor, I'm going to submit for your consideration, is the trust account ledger from the Moss Coon Fleming law firm that shows exactly what happened when they left Judge Mullen's chambers. So instead of the disbursements on the order, instead of a check for $2,765,000 to our client, these checks issued. A check for $403,500, that's one of the checks that we're here to talk about today, to an account called Forge. And you've already heard, and I know Your Honor is well aware of Forge Consulting. Forge Consulting is the preeminent structured settlement firm in South Carolina. It's the place people go when they get large recoveries to invest and structure their money. Mr. Murdaugh intentionally set up an account in his own name, leveraging the credibility of Forge Consulting by calling it Forge. And so he directs others, write me a check and send it to a post office box in Hampton, South Carolina that goes without cover in the amount of $403,500. He takes that money, he misappropriates that money. Additionally, he requests that a check be issued to Forge for $2,961,931.95. You're not going to find that on Judge Mullins' approved schedule. That check likewise sent to a post office box in Hampton, South Carolina, under his control, takes the money, apparently misappropriates all of it. And as you've heard, there's yet another check for $118,000 that he requests, and it's sent the same way. Your Honor, that is, I can't think of a more willful, open, brazen violation of a court order than that. When they walked out of Judge Mullins' chambers with that order, all counsel and Mr. Murdaugh understood what was to become of that money and willfully disregarded it. And so we have grave concern that whatever conditions you put on this bond, he will likewise brazenly disregard. That's why we're asking for tight constraints on him. Your Honor, I have copies of the actual checks. Significantly, on the $2,900,000 check is endorsed Alec Murdaugh, DBA Forge. So clearly, he misappropriated those funds to his own use in open violation of the court's order. Now, we have concern that he has been engaged in a pattern now of dispossessing himself of assets for the purpose of avoiding attempts by us and others to collect against him. We know that in recent times he has transferred an interest that he owned in Green Swamp Club, a gun club, hunting club down in Beaufort. We're not sure exactly what money he got for this, but the transaction occurred on October 1st, 2021, and I'll have a copy of that for the court's consideration. He is listed for sale a Grady White boat that he owns for $115,000. And more concerning and more troubling for us is he has granted to his son a broad power of attorney, surrendering all financial control to his son. So, Your Honor, if you do consider a bond, we would ask that that bond restrict the ability of his son to assist in the dispossession of assets that would otherwise be available to right the financial crimes that have been committed on our family. Now, finally, Your Honor, it's important to note that we're not the only victim. We're the only victims here today. Mr. Murdaugh's law firm has sued him for allegedly stealing $10 million, more or less. Now, amazingly, it's only at the time that the Satterfields came forward with their complaints that the Murdaugh law firm discovered for the first time that there's $10 million missing, right? And what they explain on their website, and this is a notice that they published to the public on their website, is that all clients have been restored. No one has suffered a loss because of this. That is not true as to the Satterfields. Right, so if ability to pay is a concern for the court, apparently Mr. Murdaugh has enough wealthy and powerful friends and family members that somebody stepped in on his behalf to cure a $10 million wrong for him. Because that's what this represents to the world on the website. I can tell you it's not true as to our clients. So if you set a bond with a high financial amount, you should rest assured that he has the financial wherewithal through influential friends and family members to respond to virtually any bond that you could issue. So, Your Honor, we ask that you issue, if you're going to issue a bond, that it be for a serious amount. He has the ability to pay. And in closing, Your Honor,
what's a serious amount? 10 million, 20, 30, 50, 100?
$4.3 million feels appropriate to us. It seems to bear some relationship to the crime that was committed to our clients. And, Your Honor, in parting, there is one other victim in this courtroom you need to hear from, and that is the South Carolina Bar. Because I can represent to you, as a member in good standing and as an officer of this court, we get calls every day from lawyers about this case with one unified sentiment: outrage. You're outraged that this has happened. outrage that our profession is stained, and with the hope that the bench is going to start the process today of restoring some integrity and some dignity to the practice of law by letting it be heard that this conduct is unacceptable and that it will be met with the full force and fury of the court. Thank you, Your Honor.
Thank you, Judge, and thank you, Mr. Bland, Mr. Richter. Very quickly, Your Honor, I provided a copy of this to the defense, but I do have for your consideration if I can approach a proposed order that's got some of these conditions for Your Honor to select or not select, obviously, based on Your Honor's ruling.
I'm happy to see what anyone proposes. Wanted to be clearly stated that I'm not bound by any suggestions or proposals by either side.
Absolutely, Your Honor. The conditions on there are not selected, Your Honor. They're just the standard conditions, and again, you know, the ones that are of particular importance, aside from a decent surety and GPS, is the wasting assets provision. He's already surrendered his passport. The no firearms provision is of significance, and the travel needing the approval of state is of significance as well. There's a number of other standard conditions that I think would be appropriate.
Mr. Waters, the statute provides that the arresting law enforcement agency shall inform the court of various considerations indicated in the statute. Title 17.
Yes, sir.
And I would like to hear from the law enforcement agency pursuant to the statute.
You would like to hear from me or the police officers, Your Honor?
You consider yourself a law enforcement agency?
Prosecutorial agency, Your Honor.
I'd like to hear from the law enforcement agency in charge of investigating that.
All right. We have Agent Turner, Special Agent Turner from SLED. He's part of this investigation.
Good morning, Your Honor.
Yes, sir. Please speak into the mic. Appreciate it, sir.
Yes, sir.
Good morning.
Good morning, sir. How are you doing this morning?
I'm fine.
Your Honor, I can say that we've worked in lockstep with the Attorney General's office on this case, and that everything they've said is completely accurate. We agree with their assessment of this case at this point in time, and we support them.
And indicated by the SLED chief that this investigation is one with a number of ongoing investigations. The statute provides that the court is to consider all incident reports generated as a result of an offense charge. In my mind, the court should consider the nature and extent of any ongoing investigation that can be disclosed that might impact upon the court's decision. How would you like to address that?
Give me just one moment.
May I consult with him, Your Honor?
Yes, sir.
Yes, sir, Your Honor. I apologize. To put it clearly, sir, and right now what I can speak on, the South Carolina Law Enforcement Division, we are investigating multiple different allegations or investigations at this point in time, to include the Stephen Smith death, which you're aware of, the actual cause of Ms. Satterfield's death. We're looking into that, the financial case that you're here with today, and numerous other financial investigations dealing with fraud or possible other criminal actions. As of right now, these are the charges that we are comfortable with and that we feel appropriate bringing forth. That's not to say that there won't be additional charges brought forth in the near future or possibly brought forth in the future. But these right now are the charges that we, the South Carolina Law Enforcement Division, felt were appropriate to bring before you today. Thank you, sir.
Anything else, Mr. Ward?
Nothing further from the state, Your Honor.
Your Honor, I hesitate to address Mr. Bland and Mr. Richter's allegations, but I think it's important for the court to understand. Mr. Murdaugh was not a lawyer in the Satterfield matter. He was the defendant. He had no authority over any money whatsoever. He was the defendant. The lawyer was a friend of his, but that lawyer is the one that issued those checks. That lawyer is the one that made sure the money went to this forge. He's the one that had responsibility. And then there's a personal representative who was a banker. They were responsible for making sure that Mr. Murdaugh could not, if he in fact did, purloin that money. So the idea that somehow he used his position as a lawyer, he was the defendant. He was the one that got sued. So make no mistake about it. In these particular crimes, he was not acting as an attorney. And he was acting as a defendant. He got sued, or they never actually filed a lawsuit. But he was the defendant. The insurance company treated him as a defendant. The insurance company decided what to pay. The insurance company wrote the checks. Number one. Number two, and I understand Mr. Richter and Mr. Bland are representing their client zealously, but that is a civil matter. If they want to deal with assets, there are ways to deal with that on the civil side, not on the criminal side. If they feel that he's disposing of assets, we don't know. I mean, they've made some allegations here this morning. To be frank with you, he has been in rehab or in jail since he was turned himself in on the charges down in Hampton County. He hasn't been executing documents except to the extent, I think the Hunt Club one you talked about is the bank getting paid. You got no money out of that. But again, that's for the civil court, not for this court. Be happy to answer any questions Your Honor might have.
Before going to Mr. Waters, Murdaugh, is there anything you would like to say concerning the bond?
No, sir, Your Honor.
Your Honor, one other matter. He's not a member of the bar anymore. If the idea that somehow he could steal with a pen, he's not going to be in a position. He's been suspended. He's turned his license in. He's not going to have any escrow accounts. He's not going to have any clients. He's not going to be able to further the scheme that Mr. Bland and Mr. Richter talked about as an attorney. Thank you.
Yes, sir.
Your Honor, he absolutely used his position, his prestige, his reputation as a lawyer to steal from this family. They trusted him because they knew of his reputation as a lawyer. They listened to him when he took them to Mr. Fleming, and they believed in him when they talked to him about the case. PMPED sent a notice of representation at the beginning of this case, which is amazing. And at the end of the case, after that last check in October of 2020 for $118,000, there was a dismissal signed. It was signed by Mr. Murdaugh himself, not by any attorney on his behalf or anything like that. So it was his knowledge of the system, it was his knowledge of Forge Consulting, and it was the belief of this family and his reputation as a lawyer that allowed him to steal this money. So it is absolutely tied to him being a lawyer. Thank you, Judge.
Mr. Bland, Mr. Richter, you indicate you have some documents you want me to review.
May it please the court, Your Honor.
Yes, sir.
Your Honor, may I add one thing?
Yes, sir.
Mr. Harpootlian is actually factually incorrect. Mr. Murdaugh prepared personal representative documents for Tony Satterfield to become the personal representative of his mother's estate. His paralegals and secretaries conversed with Corey Fleming's secretaries and paralegals about how money was supposed to be exchanged. He very much acted as a lawyer in this case. It's the strangest thing where the defendant dictates to the plaintiff lawyer how to run the case and then how to allocate the money in contravention to a court order. And we have introduced into the courts of this state the documents that show that Mr. Murdaugh actually did represent the family at the same time he was a defendant in a potential lawsuit. Thank you, Your Honor.
I'm going to take a recess to review what has been submitted and to ponder my decision. I say that I am not in any way considering personal recognizance bond. I'm not considering that in any way. The issue for me is if the court should deny bond entirely. So we'll be in recess for about 15 minutes.
Thank you, Judge.
You may be seated. Is there anything else anyone wants me to consider? Mr. Waters.
Nothing from the state, Your Honor.
Nothing from the defendant, Your Honor.
Our statute with regard to bond setting certainly starts with the premise that everyone is entitled to a bond, a penal bond, or some other type of bond unless they present an unreasonable danger to themselves or the community, or unless they present a flight risk. In considering those factors under 17-15-30, the court is to consider, among things important to me here today, the financial resources, the character and mental condition of the accused, any charges pending at the time the release is requested, all incident reports generated as a result of an offense or charge, and that the arresting law enforcement agency is to provide the court such information. The defense has filed a memorandum in support of bail in which they acknowledged and indicated that Mr. Murdaugh is a recovering opioid addict of approximately 20 years. And since then, he's spent millions of dollars supporting this insidious addiction. He goes on to contend that following the death or murder of his wife and son on June 7, 2021, his opioid addiction spiraled out of control and he became reckless in his financial dealings, at which time the firm became suspicious about missing money. He then was moved to a detox facility in Section 6. After attempting suicide on September 3rd, then indicating that he voluntarily surrendered himself to law enforcement after and coming back from Florida after there had been an indication of charges against him. The state suggests that a $200,000 surety bond would be sufficient to guarantee all the protections required by the law. The defense seeks a personal recognizance bond. I am concerned, however, with the safety issues that are present, not only as to Mr. Murdaugh, but the community. And perhaps 78% of the cases I deal with in criminal court involve someone with some type of drug problem, drug addiction that results in serious criminal consequences. Rarely 2 or 3 weeks go by without me having the occasion to sentence someone to prison for 30 years to life for murder and other offenses committed while under the influence of drugs. Here the defense suggests that Mr. Murdaugh has an insidious addiction that's lasted over 20 years, during which time he's achieved high accolades under the law. He's been placed in significant positions of trust, and he now stands accused of stealing millions of dollars through breaching trust, deception, and other illegal means. There is no amount of bond that the court can set that would safely provide protection to Mr. Murdaugh, to the community, and satisfy the conditions of the statute in my mind. With regard to the character and mental condition of Mr. Murdaugh, who's admittedly attempted suicide or engaged in a conspiracy to commit murder through a co-defendant, at least that's what alleged, with a great number of pending investigations, matters that law enforcement has to some degree disclosed and some degree not disclosed. There's no way that this court can set a bond at this time. I am therefore denying bond at this time, and I'm requiring Mr. Murdaugh to undergo a psychiatric evaluation to be submitted to the court for further consideration at a later date. And that's the order of the court.
Thank you, Judge.
Your Honor, when you say psychiatric evaluation, you're having you're going to sign an order to determine whether or not he's competent to stand trial?
No, sir. He's not competent to stand trial, but a report of his mental and psychiatric condition. I'm not relying upon representation regarding treatment from out-of-state agencies, reports of which I have not seen or received, but only representation by counsel. I'm not satisfied as to his mental condition such that I would consider that a factor favoring granting bond.
So I guess I'm asking for guidance from the court. What is it that you would like from us for you to examine?
His psychiatric condition, his mental condition.
From the treatment facility?
By whomever that can provide it. can be a psychiatrist, can be a medical doctor with sufficient credentials. That would be for the parties to determine.
And once we provide that, you then at that point consider bond?
At that point, at whatever point I might reconsider bond, it would be based on additional information that exists at that time, including anything further regarding further investigations.
Yes, sir.
Thank you, Your Honor. Your Honor, are you ordering the psychiatric examination, or you just want additional information?
I'm ordering that the defense produce a psychiatric evaluation.
All right.
Oh, I'm so sorry.